Mr. Huntley.
Yeah.
Michael Taylor.
How you doing?
Good.
How can I help you?
Thanks for coming.
Yeah.
So basically, I just came here to file another complaint. And I wanted to actually inform, a deputy in some capacity that before a conflict of interest can be valid or justified, you guys need to rectify the errors you guys provided in my case.
Taylor Sharmo, you're needed at the front desk. Taylor Sharmo, you're needed at the front desk.
Basically right here, as you can see, my public defender declared the conflict of interest without reason in direct response to me asserting my constitutional rights. Okay, and, amidst, already pre-existing violations, I've had legitimate reason to be concerned, right? So I just wanted to, leave here just with that complaint today. I was going to file a written complaint.
Okay.
And then I just wanted to basically, do my due process in informing you guys, because I know you're not going to give me clarity today, are you?
Nah, there's nothing what I can do, I can update your file that you came here. Who's your new attorney, though? You have
I have a bar panel.
Okay.
And, I just had to file a complaint on him with the state bar today. Unfortunately, because there's just too much compelling evidence that he's colluding with you guys to, just by giving me bad legal advice, telling me to proceed with an evaluation when I've been asserting my rights before the evaluation began, So, again, I just want to make sure that my rights are upheld. That's it. That's it. That is it. I think, I don't know why I have to, be treated. I understand I'm a bit overzealous. I can be a bit overzealous, but my sense of urgency is high because the matter is serious, right?
Absolutely.
The charges are very serious, and it's been a long time. Like right now, I have legitimate business to take care of, and I can't really do it because I got to hang around Los Angeles, be homeless, okay, and basically pursue due process on my own, and I just don't really appreciate, my constitutional rights being neglected throughout the entire process. Listen, I don't expect some $1 million defense. Come on, but in terms of, the law being applied evenly, okay, I think that it doesn't really cost anybody much for my lawyer to, preserve the rights I do have.
What the status of your case right now? You're on mental health diversion right now?
So yeah, Ms. DeRocabelle coerced me to accept mental health court, okay, without showing me the report. Okay, I still haven't received the report. The bar panel attorney is deceptively nuanced legal maneuvers to divert the fact that I'm asking for the report. And they just keep ducking and dodging, and I just feel like, look, any claim that I'm trying to make or any information that I'm trying to receive as it pertains to my case, it doesn't just absolve me from liability, right? So just because I have the information doesn't necessarily mean like, oh, I win now, right? So at the end of the day, I just want to make sure that, my defense counsel is being transparent. If I have legitimate reason to want to know information pertaining to my case, I'd like to know it. Not to be nefarious in any way, not to be, not to undermine their job, basically. And that's the reason why I've ended up in this position, because even though I've disagreed with their interest in the case, I've still deferred to them. Why? Because they're the professional. Okay, so even against my better judgment, I've still cooperated. And now I'm in a position where you guys declare conflict of interest, to avoid responsibility for the violations you did do. And now, my public defender, he wants me to proceed with the interest after you guys declared a conflict of interest. So I have so many reasons as to why I should even proceed, considering the fact that I am cooperative with, pursuing mental health diversion.
After you complete mental health diversion, your case gets dismissed.
I do understand that, yeah. So my only concern is, why does me pursuing mental health diversion have to come at the expense of my rights being violated? Okay, I like to think that I had legitimate legal claims initially. hey, they sold the car. You didn't let me know that until I asked about it. So I just learned that, it was destroyed before I even made it to arraignment. Okay? And then you don't want to object to it. Okay? Right? The omission of critical details in the police report, leaving me vulnerable to this guy.
You have an impeccable vocabulary.
Yeah, listen, I'm very, and that's what. Listen, there is a way to fix this, and that's why I'm trying to work.
Go ahead. This has nothing to do with the case, but just my curiosity.
Yeah.
Where'd you go to school?
Well, I mean, I haven't had much college. Everything is applied knowledge.
Wow.
Listen, I'm gonna be honest with you.
I'm impressed, man.
I'm gonna tell you, I asked God for knowledge, wisdom, and understanding.
He gave it to you. He gave it to you.
I'm trying to.
He absolutely gave it to you.
And look, with that comes a responsibility of, okay, if for any reason you believe, I believe that I might understand better than others, you know what I'm saying? I still have to understand, the contrast. Okay, now that I might perceive things better than someone else doesn't mean, other people are, stupid for that matter, for lack of a better word.
Yeah.
But basically, look, I just want the information I have a right to. All of my, requests to Mr. Lay and Miss Bell have been, for the most part, well within the scope of duties and obligations they have to clients. Now, I respect you guys as attorneys. Yeah, you're public defense counsel. You guys can't, you guys have hefty caseload. I understand that. At the same time, what I don't understand is how we can expend so much money on expert witness doctors instead of defending the constitutional rights I already have. Okay, I already have.
It just seems like that it's a different idea of strategy for the case. So, like just to give you an understanding of how it is, strategy for the case is
not
determined by the
defendants'
attorney.
Legal avenues.
Yes, it is, but it's determined by the attorneys, though. So the strategy.
See, that's the problem. Attorneys are not supposed to impose their interests in the case of defendants. That's fundamental, right?
But your goal is probably no different than the goal of the attorney.
Well, that's for me to say, because
what's your goal
with the legal claims?
Yeah,
to ensure that the law was applied evenly.
But is your goal to get the case dismissed?
If it calls for it, yes.
And if it doesn't call for it, then what?
Well, I at least was able to preserve the rights on the preservation of my rights on the record.
What would happen if you decided you wanted to preserve those rights, and then you ended up going to trial, you lost at trial, and then you ended up getting incarcerated?
Well,
that's a risk that you would have to take. But
that's the risk that's there regardless.
Absolutely. But if that risk is mitigated, where you don't go to trial and your case ends up getting dismissed, you end up at the same.
I get to beat the charges essentially. Yeah. Right.
It's the same outcome, just different methods to get there.
Right. However, when we talk about the fundamental principles of justice, okay, the bedrock of our, democracy, if you will. As a man, I'm 34. The world is mine, essentially. Figuratively speaking.
We both know that this system of justice is not just, though.
Well. So here's what I believe. I believe that life may not be unfair. Doesn't mean that the law doesn't have to be. It doesn't mean the law has to be unfair where it can be held. Okay, and so as a man, U.S. citizen in this country, because I got residence and business in other states. As a man, I deserve to have the power to stand on my constitutional rights in a court of law.
But what if that right
not be subject to the interest of somebody else who's already predetermined the neglect of my legal rights?
But what if standing on that right means that in the end there's a possibility for you to be incarcerated?
So are you telling me that me asserting my constitutional rights comes at the expense of diversion? So if I assert my rights and make legal claims, that means I cannot pursue diversion?
Not necessarily, but if because you assert those rights, I'm not saying that I don't know too much about your case, but I'm just talking about this in a vacuum and hypothetically. to get diversion. In your case, for your diversion, did the district attorney agree to diversion, or was this a contested hearing where the judge granted diversion over the district attorney's objection?
I think it was something my defense counsel pursued before the district attorney became aware of it.
Was there a hearing for diversion, or where they had to put on witnesses and the DA said they didn't want you to get diversion?
I don't know. You're gonna have to ask Ms. Bell or Mr. Lay. Because I've seen so many doctors at this point.
Yeah.
Okay.
That's just my thinking. I don't know what happened in your case.
So the thing is, in 2015, I was in Mr. Smerling's court. Okay, and I, had an emotional breakdown. And, it was truly a mental health situation. You know what I mean? And in that case, I was thankful to have had, diversion as an option. You know what I mean? Because I actually had the breakdown. Right. In this case, I don't like the idea that, I have to, be presumed guilty. You know what I mean? By pursuing diversion.
But you're not presumed guilty.
But it is.
There's no plea in it. You only enter your not guilty plea.
Well, I'm treated as though I'm presumed guilty.
What do you mean by that?
Because for me to just pursue diversion as if I can't, challenge the application of law at the appropriate stages, right?
What would you have rather done instead of gotten mental health diversion?
Well, so here's how I envisioned it happening. Right, because at first, I was appalled by the nature of charges.
What was the charge?
Attempted murder, felony, and misdemeanor hit and run.
Okay.
Now you got to also remember that upon my arrest, I don't think I made it to. I got arrested in mid, a week before Thanksgiving. I didn't make it to court till like January, February. Right. So
why did it take so long?
Because they quarantined me. Because I didn't want to take the swab.
Got you.
But they psych evaled me because I was a little too vocal about it.
This was a car case where at some like a 7-Eleven or something?
Yeah.
Like that, somebody got?
Yeah. The bar panels had already told me I shouldn't be dealing with this. This case, listen, my case has been delayed under the condition that the public defender is not gonna.
Well, okay, tell me what would you have
They're
wanted
not
to
gonna
happen?
assert my legal rights, man.
Which rights?
All my rights to due process, making sure I have adequate paperwork that I'm expected to make decisions on in court. Okay, to object to destruction of evidence that directly undermines my initial legal claim.
And what evidence was destroyed?
The car. Okay.
Okay. And
he tells me, oh man, they shouldn't have done that. They weren't supposed to do that, Mike. Okay, they weren't supposed. Like I don't know. Like I don't already know.
Okay, and if the car wasn't destroyed, then
so
how would that have
basically,
changed?
so because they are already omitting critical details, okay, of the complaining witness participating in the incident that directly affected the outcome of events, okay, he compelled me to flee. I had no reason to flee until I seen it. He compelled me to flee,
right?
Okay, which is compulsion as far as I'm concerned, okay.
So you would rather present that defense at a trial?
No, I'm just giving you the context and the basis.
I understand that
for where I'm coming from. I'd rely on you guys to assist me in actually formulating.
But even with all that, let's say that the car was not destroyed, you were able.
Right. So basically, because they omitted that, and the lawyer already failed to object to the omission before I even knew about it.
But
okay,
your case is not going to get dismissed because the car was destroyed.
Okay, but you got to understand, it's not just about the car. It's about the compounding violations. Okay, look, so
where do you want to assert that defense? You want to assert that defense that you were compelled to leave
any
at trial.
defense that I want to assert now is too late. Okay, no. I'm under precedent.
Let's go back before you got mental health diversion.
Okay,
you said that you want at some point you want to. That's a defense that you have, and you want to assert
this
that
is
defense.
What I wanted to do was I wanted to cite discriminatory elements at preliminary in Burbank. Okay, when I met Mr. Lay in the tank where we meet our attorneys. Okay, he disregarded my chosen legal strategy for a frivolous fact-based argument that had nothing to do with me. Hold on.
Go ahead.
Had nothing to do with me or why the case should be dismissed against me. Okay? This other party, this guy in the black Toyota Sequoia who pulled in and was the alleged victim postured at this guy and all that. Completely irrelevant. Seeing how the alleged victim's already on camera committing a crime, so we don't need these details to prove what he was going through.
So you want that information to serve at the preliminary hearing?
So, basically what I wanted to cite at the preliminary hearing was the racial differences between me and the other parties. Okay, I'm a black man. I am a black man. Okay? Came out of a black woman. I don't know my dad. I could blame that on the county, but that's another conversation.
How does that benefit you at the prelim, though?
Well, basically, it sets the precedence for my equal protection claim. If I can tell them that, hey, it ain't just the fact that I was attacked by two men of another race. I was attacked by two men of another race who actually attacked me. Okay.
And so the only time to assert that would be at your trial.
And so why does it only matter whether or not Michael committed a crime if we got video evidence that we're all culpable?
Okay. So
if it doesn't violate equal protection.
So when do you assert that?
At pre-trial. So basically, when I cite the discriminatory elements at prelim, I follow up my 995 with a motion to dismiss for equal protection violations. Boom. Based on the fact of the racial differences, and let's just be real, the prosecutor's been failing to admit that I was even attacked at all.
So let me tell you where that strategy gets you. The more information you provide at the preliminary hearing does not benefit.
Listen, these are just legal challenges. What information?
I understand.
Listen. Right now, I'm subject to being committed to a state hospital, and my rights have not been preserved on the record. That's my problem here. Okay,
I understand that. But
and I've asserted these rights before the evaluation even took place.
But when those rights are asserted, what's going to happen after that? At the prelim, if you assert that at the prelim, your case is not getting dismissed.
How can you just say that?
Because I've been doing this for 21 years.
Okay, but how can you say that? Give me the basis for how. Based on what is it not going to be dismissed?
Because I've done 1,000 prelims.
Okay, but give me the basis. Why? I need you should be able to explain the usual condition.
It's not an affirmative defense.
It's not about it being an affirmative defense. It's about challenging the application of law.
No, the only way.
Now listen, whether that warrants dismissal or not, okay, I'm on record challenging that. Okay. I can live with that.
But you being on record challenging that does not help your case. And my job.
How does it not? It doesn't help you guys defend these rights.
No, it does not.
No, because now you guys aren't liable to them because they're not on the record.
No,
yes.
The record means very little unless this case goes to trial and or the case is appealed.
Okay. These assertions should not come at the expense of pursuing diversion.
So your option would be to assert that at the preliminary hearing.
To cite discriminatory elements at the arraignment, if you want to be real. Miss Ramos crapped on me the whole way through. These are two men of another race. That's been my position. I was attacked by two Armenians in Glendale. Come on now. Why do I have to spell this out? Okay.
But you're not. What I don't think you understand. I mean, I understand your argument. What I don't think you understand is that you asserting that at arraignment or at prelim does not get your case dismissed.
Okay, but that's not the point.
It absolutely is the point.
No, it's not the point.
What's the point?
The point is that I preserved my rights on the record. I have public defense counsel. If you guys are going to predetermine...
You can assert your rights on the record, but that can still get you incarcerated.
So here's the deal.
Our job is to keep you out of prison.
Okay, listen, I understand your experience, and it means a lot. It truly does. It carries weight. I hear you, and I'm not here to refute it. You know what I mean? Because, I mean, you've experienced it. I haven't. I've experienced one, right? But unfortunately, there's just, they've just imposed their interests in my case. And
I know you disagree with what happened, but...
Well, it's not that I disagree. It's that you guys actually violated my rights.
The issue is that... Okay,
you understand that, though, right?
I understand what you're saying.
Okay,
that doesn't make it accurate.
So let me ask you this.
Yes, sir.
If they destroyed my vehicle and you guys had knowledge of it, and you guys had knowledge of where I was when I was in custody, okay, and you guys failed to object to it against my will.
What's the remedy for After we object to them destroying the vehicle,
if they're gonna omit details pertaining to the complaining witness's criminal liability, then I needed the vehicle to examine the forensics on the car door to prove that Robert Yagavav put his hands on the door.
But that's on the video, though, right?
Well, you guys are acting like you ain't seeing a man compelling me to flee. It's not in the police report.
I don't think anybody said that because
But it's not in the police report.
But you don't. It doesn't matter what's on the police report because you have a video of the entire incident, right?
Okay, well, why aren't we addressing the omission?
Okay, the time you address the omission is when you go to trial.
No. Why are you assuming it's already a fair trial?
I'm not. I started this conversation saying that this justice system is not just.
Listen to me. It's already an unfair trial if you guys are going to predetermine the neglect of my constitutional rights in any capacity. Now listen, you can say that you disagree with how I claim you violated my rights just because you guys take nuanced approach and it's not a big deal to you. But let me exemplify how you guys violated my rights, okay? Mr. Roca-Bell coerced me, okay, to accept mental health court while denying me access to the report. Okay? Why would she do that? Because she used my religious beliefs, okay, to influence the report. Ain't no way there can be.
She used your religion.
I still don't have a copy of the report because she's trying to cover it up. I'm trying to tell. I've been emailing y'all.
The police report?
No.
What report are you speaking of?
The expert witness doctor report. Listen, if she would have told me that it said I was incompetent, or if I would have known that she used my religious beliefs.
But you're on mental health diversion. You're not in mental. Are you in mental health court or are you mental health diversion?
That was criminal proceedings in Pasadena.
But hold up. Right now, you're on mental health diversion.
Now,
so
yes.
Criminal proceedings have not been suspended, right?
They have been suspended. That's why I have constitutional issues here. Pre-existing issues that suggest foul play.
A doubt was declared.
A doubt was declared based on a biased report that you guys didn't give me a chance to object to.
Okay, and then at some point you were found competent?
No, I'm going for the second opinion on May 2nd.
Oh, so you're still in mental health. You're not on mental health diversion. You're in mental health court.
Right. But I'm not supposed to be there, Mr. Huntley.
I got you. Okay, I thought you were on mental health diversion.
That's what we've been... Listen, so basically what I'm explaining to you here is, because I appreciate your time, is that if I would have knew the nature of that report or the doctor's findings or anything about that report, that how it turned out to be, before going in court that day, I would have said no, because I was already enrolled in psychiatric treatment with prototypes referred by by the public defender's office, and I've been getting a lot out of it. Okay, so I was like, well, okay, no. They knew that listen, we had a phone conference the day before court. Court was February 14th. We had the conference on the 13th. Okay. She gets the report after the conference, but right before the court date. And then you just tell me it's favorable, but you're not transparent with me. Okay. And that's a real issue because accepting mental health court, it wasn't until I got into Hollywood where Mr. Samaji informed me that, without even having my case file, mind you, okay, that, if I fail this one, I'm going to be committed to a state hospital. I didn't agree to that. Okay? Why would I agree? Why would I put myself in a situation if I'm already enrolled in mental health treatment and already pursuing diversion? Why would I accept mental health court against my better judge? Why would I do that? Okay?
If you're not in mental health court, then your proceedings would not be suspended and you would be on track to go to trial on an attempted murder case, right?
Wait, say that again?
If you were not in mental health court right now.
Well, no, because we would have just, proceeded with the diversion.
They offered mental health diversion on this
we were actively pursuing it.
But I know pursuing it is something different.
So Ms. Roca-Bell informed me that she believes Ms. Clover is highly likely to grant this in your case. She thinks that there's equities involved across the board here, and she thinks that could be a fair resolution to the case. I'm saying, okay, Let's do that. And I do feel bad for what happened to the guy. I mean, come on, man. It's not in my history to do nothing like that to nobody, man. So I just feel like, come on, why am I being penalized for taking lawful precautions, bro?
I got you.
So I'm being penalized for asserting my constitutional rights. You're subjecting me to a psych eval against my will. Come on, man. Come on. You at least have to understand how that looks to me. At the end of the day, I haven't been able to make no objections or challenge nothing, which basically gives the prosecutor to build upon speculation. So why every time I go to court, I end up leaving mad? And I wasn't mad just for the simple fact that I'm facing the charges. I end up mad. I didn't realize it until the first day at mental health court that it didn't go right. Okay?
But there's a big difference between you and other people who are, let's say, similarly situated, charged with an attempted murders. Well, when you finish quit court, you get to leave court. You get to walk out that door.
Okay.
The vast majority of people charged with attempted murders.
Well, I understand. I don't take that for granted. Yeah. I don't take that for granted. You see, I've been out for 2 years, no trouble.
Right.
Okay.
Right.
I mean, not even so much as a ticket. Okay. And it's been hard for me.
Which is good, because that's something that the attorney can argue for mental health diversion.
Yeah, I mean, listen, I have everything going in my case to get mental health diversion. It's I already got the mental health history as it is. Right. But for public defense counsel to build a mental health case around issues that really have nothing to do with the bearings of the case, or says nothing about how the laws applied against me.
But it does have to do with
here's what I believe,
because they're trying to get your case dismissed.
Well,
they're trying to keep you off the trial track to get your case dismissed.
What prosecutors need to do is ensure that the laws applied fairly to begin with. That's where I'm coming from.
I agree with you on that, but these days it doesn't happen that way.
Well, then we're going to see to it that it happens. You see, I'm standing on constitutional provision. If the court is going to violate my rights, then I just want them to understand that they're doing it.
Would you rather risk your freedom?
Listen,
let
me explain something to you. Okay? I've spent all of my 20s fighting homelessness. Okay? Still managed to drop hundreds of magazines. Still managed to pursue all of my creative endeavors, all of my entrepreneurial aspirations. Not all of them, but for what I've been able to do. Okay? At this point, I've been surviving on $3 a week, bro. So, if you can imagine, my value system is probably not the same as your typical defendant, right? Because I've been deprived of so much for so long, right? Although I'll make $300 before noon and have to give it all away to other contractors to do my work. That's I'm perfectly capable of doing, right? All because public defenders stalled my case, okay, to avoid having to uphold my constitutional rights. Again,
I think the attorney might see it differently
because you guys are perceiving my constitutional rights as affirmative defense. No, these are just basic preservational, measures. Okay? What was so wrong about my public defender at some point just going in there and saying, Your Honor, my client has reason to believe that the charges against him are discriminatory for X, Y, and Z.
How does that benefit you?
What do you mean? How does it gives me it satisfies due process? That's how it benefits me.
Saying that.
Listen, if I have that challenge, So I'm telling you, as my public defender, so to speak, that's the challenge I want to make.
I wouldn't do that.
Okay, well then we got a problem.
If I was your attorney, I would not do that.
Well, in Houston, we got a problem. Okay, you guys can't impose your interest in my case.
Well, the attorney's in charge.
Okay, but you can't listen. If I go to try, if I'm telling you to do something as a competent defendant, okay, it's incumbent upon you to do it to the best of your ability.
Not necessarily.
Well, then now you understand how you end up violating my rights. Because at the end of the day, how are you gonna coerce me to accept mental health court without giving me a copy of or showing me the report? How do you explain that?
I don't think.
How do you explain?
We both have. Everybody has the same goal.
How do you explain this?
Everybody has the same goal.
I have a right to effective assistance of counsel. That's a constitutional right.
It looks like your counsel's been affected because you're out of custody on attempted murder.
Okay, thank
That
you,
seems
but
like
but
pretty
the,
effective
but see, unfortunately, the case should have been dismissed if you guys made a legal argument. Here's why.
But none of those arguments that you're making would get your case dismissed.
Here's what. Well, you're saying that like, listen to me, Mr. Huntley. You're speaking as if Glendale didn't already prejudice the police report. Okay, hold on.
But the thing in your case, it doesn't matter what the police report says because it's a video.
And you guys don't even have a case at trial. I'm trying to tell y'all. That's what I'm trying to tell you guys. There is no case to be had.
So would you rather,
unless it violates my constitutional rights?
So would you rather go to trial and try to get
So you're telling me that because I assert my rights that I forfeit diversion?
No, I'm not saying that. Well,
then what are you saying?
I'm saying that the attorney
what I'm telling you
makes some strategic decisions.
Is that at the appropriate stage of proceedings, if I want to challenge the application of law against the prosecution, I have every right to do that.
You have every right to want to do that, but the attorney makes a decision.
No.
What's going to happen?
Well, you have to represent me, but you don't define my interest. You understand that, right?
If I was the attorney on the case, I would make all the strategic
calls.
If
you're going to make decisions that I didn't approve of, there's the problem right there. Why didn't you declare a conflict of interest then? Why didn't Mr. Lay declare the conflict of interest when I was making demands that he assert my rights? You're saying you don't do it because you guys neglect the constitutional rights of defense. It's just that simple. Listen, you haven't objected to nothing legal. Listen, I'm sorry because I'm just a little zealous about my case. Regardless of whether I asserted my constitutional rights or not, public defense counsel had an obligation to object to suppressions of evidence. Okay, through omissions and unlawful destructions, I was not given notice, even though every department.
What evidence should have been suppressed?
There's no evidence that should have been suppressed. That's what my argument is, sir.
You just said that
they got rid of the car that was crucial evidence. They should not have done that.
Okay, even if
they did do that, they should have gave me notice.
But even if here's the thing. The remedy for them destroying the car would probably not be dismissal of the case.
Not in and of itself. You understand. But you see, because Mr. Lay made that frivolous fact-based argument, right? He basically stole the authority from the judge to assess the claim. You know she can't rule on fact-based issues. You know that. So when you tell me...
A prelim is about fact-based issues. A prelim...
No. I can assert legal issues if I see there's a reason to assert legal issues.
If the attorney decides...
No. See, that right there is a conflict of interest, okay? You can't tell me that I don't have a fundamental right to protect my rights in court. Who's telling you guys this?
That's the law.
That's not the law.
All right. Well, we have a fundamental.
Show me why or where defendants don't have a right to assert their constitutional rights.
The attorney makes all strategic decisions.
Okay, no.
So, here's the thing. I appreciate. I mean, I have a meeting to go to. I appreciate.
I don't think you got a meeting though. Well, that's just the usual thing to say.
I've been sitting out here.
But whether you do or whether you don't, go ahead.
I've been sitting out here 30 minutes with you. We've been having a decent discussion. But at the same point, I'm not going to move you from what your belief is.
Well, no, I'm just trying to understand because I don't understand.
I explained it to you.
Okay.
That all strategic calls in the case are made by the attorney.
Okay, that's a problem. That's a problem.
That's something that I can't help.
Okay. So that's what I need to file a complaint on right there. Okay, because...
Yes, ma'am.
I'm sorry. Ando buscando un abogado de oficio que hable español.
Oh, just come right up here, and they'll find you an attorney. Yeah. Can you sit? Yeah.
Yeah. Gracias.
Sure.
Gracias.
So listen. You guys are in charge of strategic decisions. If I have reason to believe my equal protection rights are violated, who are you to tell me you don't have to raise that issue? That's crazy to me. No, listen, do you understand what that means? You understand?
Opinion.
Okay, so basically, where do y'all get off imposing that? strategic decision, not if it violates the rights of defendant. It infringes on my rights. It's not strategic.
But I don't think it infringes on your rights.
If you don't object to a suppression of evidence by law enforcement, what do you call that?
All right.
What do you call that?
If this, here's the thing.
What do you? There's no way to justify. Y'all gotta help. Y'all gotta listen. No, the law is fairer than that. Okay.
Well, I think we have different opinions.
This ain't opinions. This is fact.
No,
okay.
it's
Things transpired in my case that have violated my rights to effective assistance of counsel. And you guys have declared conflicts of interest to absolve yourselves from liability.
Like I said, I think your counsel's been extremely effective because
effective.
You're on a attempted
I still
murder
don't.
case and you're out of custody.
Okay, but
you have a chance to
I'm
get your
out
case
of custody.
dismissed.
Listen to me, man. Listen to me.
So here, I'm gonna head back. All right, I appreciate you coming up here. Absolutely, I appreciate you coming up here.
You guys need to get this right.
There's
We
nothing
need to fix this.
There's nothing else I can do for you.
Listen,
all right.
You can't tell me. You got to show me the statute where public defenders have a right. Where's that at? Because you got to show me that.
I don't have to show you that.
You need to.
I've come out here.
You came and gave me some legal advice. That's legal advice.
I'm not giving you advice. I'm
that
telling
was
you
advice.
Okay, well,
you're basically saying
I'm not
that.
here to give you legal advice.
Okay, but you already gave me legal advice. You basically, you basically told me.
I told you that attorneys make strategic calls in cases.
Based on what case law precedents? No, please.
I can't give that. I don't think
you can because you said there's certainly case law that supports what you're telling me.
I'm not your law clerk.
You have
I'm
a
not
case
gonna,
law
I'm not gonna.
you can cite.
I'm not your law clerk. I'm not gonna go back and do legal research for you.
But you say you know
appease
this.
You, okay?
You say you know this though,
sir. I appreciate you coming. I'm heading back. All right. You have a great one.
Okay.
All right.
Do you have any formal complaint forms?
I do not. You can ask here. I don't know if we have them. But
okay, you're a deputy here, right? What is your job here?
My job is to come out here and talk to you, which I just did.
Okay, but I'm still not understanding what statute
There's
gives
nothing I can do to appease you. Sir.
Okay, but listen, what statute gives you guys the power to make strategic
decisions? I am not
decisions?
your law clerk. If you want to do research, you can always do the legal research. Okay.
What about effective assistance, the Sixth Amendment? Explain to me what that means.
Sir, I am not your law clerk. If you want to learn about the Sixth Amendment, you can always go and research.
Okay, but you guys have provided ineffective representation.
That's your opinion. I disagree with that opinion. I disagree with that opinion.
Listen, you guys have been...
Sir,
I still haven't received a report.
Okay, sir, I've been out here 30 minutes with you.
Okay, so all right, last thing. Would you say this is alarming here? This email where Mr. Samaji declared a conflict of interest without reason in direct response to me asserting my constitutional rights.
You need to discuss that with your new attorney.
Okay.
All right.
I'm asking you.
I'm not getting into
Is this alarming?
I'm not getting into that.
This is your attorney.
Okay, but I'm not getting into that.
Okay, but this is your attorney who rendered this in my case. Okay.
Speak to your new attorney about
But you're a head deputy, right?
I absolutely am. Okay. And I came out here, I talked to you for the last 30 some odd minutes. Sir.
Okay, and I appreciate that. Right, thank you. Yeah. But this email here is a violation of my constitutional rights. First of all, I have a right to know the reason. Okay, for declared conflict of interest.
That's fine. Okay. Absolutely, you do not get to know the reason for the conflict.
I mean, if it's in direct response to me asserting my rights, I mean, you guys didn't declare one before that. It was 3 different offices.
I appreciate you, Sasha.
I just want you to understand that I haven't received any legal correspondence about any conflicts of interest. You guys
you
don't
get correspondence about a conflict.
Okay, but if there's a legitimate one,
we don't notify the court the reason of the conflict.
You can't do that. That's a violation of my Sixth Amendment rights.
It's not. You have a great day, sir.
It is.
Thank you. You have a great day.
All right. All right, so we've been denied, clarity on the matter. Mr. Huntley has basically informed me that public defenders get to make strategic decisions in their client's case, even at the expense of their constitutional rights being violated. That's what I'm going to have to file a complaint about because there's no reason I should be treated with prejudicial treatment without, asserting my rights here. Okay.